Yes, yes, Lordship. Lordship, I recommend item number 17 and 18, Lordship, is the concern of the other party.
Mr. Purakumar suffered an injury.
What is it?
Lordship,
Yes. One sharp weapon fell on his leg and it cut it. One sharp weapon with which he was working, it fell on his leg and it cut his leg.
Oh,
item number 17, Lordship, I got the instruction that we will go for the second T1 statement.
That's
17 and
313 for the second time.
17 and 18. Okay. On the both sides are represented. On the player maker and counsel for the appellant. Matter is adjourned today. List after
On 7th September, Lordship.
Week starting from 11th.
week starting from 11th. The week commencing from 11/9/2023.
Master.
Therefore, receipt of this criminal litigation.
Testing, give it to the court master. Listing, give it to the court master. Yes, item 1.
Daily recycle. Item 1 for motion.
This case matter was already your lordship issue of this matter. A base mile of 140. Item 1 and 2. 145 your lordship.
Same order, 145.
145. It's now 4592 of 2022. 140.
And instead of page 146, none appears. The same is should be part of counsel for the respondents is so as well as the product counsel for the respondents. Here for all the respondents, same one. Later on, we will make it same day, 59.
Along with 4592.
About 59. List along with same. Items will same. The two will same. Item 3. Yes, Mr. Professor. For the first time, let the issue notice. So Mr. S.D. Purkar is the counsel for the petition, sorry, appellant. Agreed by the dismissal of the dismissal of matrimonial suits number 65 of 2021 by judgment and order dated 17/7/2023, which was filed under section 13(1) within the Roman 1 of the Hindu Marriage Act. The present appeal has been preferred under section 19 within bracket 1 of the Family Courts Act. Yes, item 4. It's come for the first time.
First time, yes.
So the is on the counsel for the appellant. For the first time, admitted for the records. application notice.
376 notice is not required. 376 notice is not required. Only POCSO. Lordship can send it. But
No,
then
let it go.
Lordship-
Let it go.
I'll file my objection.
I will take it up after receipt of LCR.
Yes, yeah.
Then should take steps in 2 days for service of notice in the informant. I will respond to the registered facility as well as the usual process. To be served through the jurisdictional magistrate. Separate application, IO. IO. Set notice. The steps. So, shall be considered on receipt of the LCR. We take steps within 2 days.
Item 7,
So it doesn't matter. This A or the appeal both. You want to withdraw the interlocutory application?
Yes, no.
So, understood. Okay. Your name? Ms. P. Barwa, Senate Counsel appearing on behalf of Mr. B. Dekar, counsel for the applicant. Upon instructions, it is submitted that the applicant has instructed her to withdraw this interlocutory application. There is allowed the interlocutory application and dismissed from the table. Resulting there, the connected unnumbered amity appeal. Right, filing serial number 291004 dated 10/2/2017. Stands dismissed. Together with connected interlocutory unnumbered interlocutory application. First the also stands dismissed.
item 8,
Dismissed from the group.
8 I had served on the last occasion, the notice was not served, that is how it was not taken up. I have served the notice, I have told the police officer to serve it. He has served it. But the lordship will be surprised to see the service actually. The letter that I had written to them, that was served upon the informant. And he had taken photographs and all. He had served the same letter on him and on her, and by taking her thumb prints there. That is there, Mr. Rakesh can take out. Photographs are with me. He has otherwise served it on that lady's name is written there. Let's see. Amir Hussain, yes, the person's name is also there. Bakpur Police Station.
But where will I find it?
Lordship will get that.
Oh, acha.
Print. He had sent it to me. It was signed by. But it was signed by Samira Nessa. Simon Nessa. Wife of Amir Hussain. And Kodong
Simon Nessa.
Simon Nessa is the wife of the informant, Amir Hussain. Hmm. And And number 2 is Roxon something. Oh, that is witness.
But this would not be an appropriate service.
No, this will not be a problem because he is otherwise not the informant
No,
and
no,
he is a
that
lady.
she may receive it. So that is permissible under the,
No,
yes, yes.
no, that is not permissible. A male member, adult male member has to receive section 62 IPC. CRPC section 62 Lordship will say. Sixty-four.
Just from
No, 62. But there, a rider is there where the person summoned cannot by exercise of due diligence account. The summons may be served by leaving one of the duplicates for him with an adult male member or his family. Decided to him as a person with. It's okay, Lordship, like 62 doesn't provide, only 64 if persons is not found.
no, just from.
Sixty-two is otherwise okay. Yeah.
Ah, Why the endorsement is not because well, unless I reconfirm what I remember, it will not give me peace. So,
So criminal rules.
Huh.
High Court rules criminal.
well, process are served through the criminal process.
Ah.
So, rule 6. There's something I remembered, so better to 6.
If after due and reasonable inquiry, the person addressed cannot be found, service shall be effected on an adult male member of the family. Same as 64. But here it's not the case that she could not be found because Amir
No, I
Hassan was
understand that,
there.
but this male member comes here. So that's right.
Second to 64. But the fact is here Amir Hassan, they got it. Only they took the signature of his wife. And what he's saying that family members of the informant, if they receive, it amounts to good service.
So, Mr. Mahmood, again, your matter has to be postponed.
Technical matter, I think Lordship exercises the discretionary power because.
No. That will be contravention of the Supreme Court judgment. It will not be appropriate.
Husband received the notice, but police, due to mistake, has taken the signature of wife.
No, it's okay, but to accept it would be not in accordance with the High Court rules. Because now we'll have to say how they will serve it. Otherwise, they make the same mistake again.
The Lordship will see section 62. 64 will come into operation when they cannot find the person to be served. Here, this is not the case. 62 will cover. Every summons shall be served by a police officer or subject to such rules as the state government may make in this behalf, by an officer of the court issuing it or other public servant. The summons shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons. Every person on whom a summons is so served shall, if so required, by the serving officer, sign a receipt.
So this time you tell them we'll fix it after 10 days,
Ah.
but you tell them this is how it is to be served.
But they pay, I was satisfied Lordship of this way. Can we take up the matter tomorrow?
No, not tomorrow, we can take it up at 2 o'clock, but tomorrow we don't know. You can take it up at 2 o'clock if you want.
Creating service. And the case Lordship has perhaps come to the record. There is no merit atonement. She
No,
has-
we don't know that. You
has
maybe,
changed her views every now and then.
no, that's okay. But
And all the witnesses have said there is nothing. As Guwahati, she fell down, then the sustained injuries. Later on, she started saying a different history. One thing per year.
no, you may be right. We are not disputing what you are saying right now.
Lordship will take it up at 2.
Let him show us that it can be considered.
All right.
Item 9.
Yes. Just 2 minutes. So, Mr. Having regard to the materials available in the case diary, as well as the trial court records, we are not inclined to grant bail. Primarily because there is a dying declaration which instincts confidence that it was appropriately recorded. It was recorded in the presence of the doctor, and it was taken by the recorded by the executive magistrate. Huh? May not be, but executive magistrate was there.
Applicant number 2, man, she is 78 years old, and not paying for clean. She contains age in admin. Applicant number 2 only.
Before the circle officer, mother-in-law was implicated. In her dying declaration, mother-in-law was implicated. He is praying for.
But 78 years, you can still consider that factor.
Only for applicant number 2, man. One child is there, who is no one who is after him.
In this, having regard to the age of the applicant number this 2, my sister is suggesting that you would have you would have her examined by the doctor and have a report of a condition.
Age along with ailments, then in that case, bail can be granted. But age as such cannot be a factor actually as per the Supreme Court's. Yes, I'll get a report from the doctor later.
Mr. Harish Mishra, counsel for the applicants, and this is Jahan for the state. The non-counsel for the applicant, the applicants have submitted that the applicant number 2 is aged 78 years. Considering the age of applicant number 2, namely Gauri Roy, court is inclined to call for her medical examination report.
He's in Dibrugad jail.
Accordingly, the deputy shall transfer out of this court to the superintendent of the jail, Dibrugad jail. So as to have the applicant number 2, Gauri, Srimati Gauri Roy, examined by the doctor and medical report be sent to the court. This on after 2 weeks, List after 2 weeks, awaiting list of the report.
Item 10.
Yes. Kindly.
Item 11.
Kindly peruse the notice number 24 service limited of the customer.
So student by usual course now. This is OXO. So the state will take steps. OXO matter. So each of these and comes to the sorry, which both sides are really represented. On the clear made by Mr. Akiri Chaudhary and standing also for Nia. They are appearing as standing also. Now DSG appearing for the respondents. Yes, for and it's rather 2 weeks for the time to file rejection of the appeal. List of 2 weeks.
Item 14.
Yeah, as far as the IA is concerned, Miss A. Begum had taken time on the last occasion. I'll see whether she has prepared and filed it. Otherwise, she doesn't appear in division bench much. Perhaps I was not there on that day. I'll confirm whether she has filed. She has not filed, it's not there in the records.
No, he will know it.
Uh-huh.
If you file it, he will know it.
Yeah, I'll have a talk with.
Not file.
I'll tell her to file within a 2 or 3 days. 7th, I'll tell her to file. A. Begum.
This will be the third day. This will be the third date you will be taking for filing of objection. The LCR has come in the meanwhile.
Yeah.
Want to go through it?
Lordship, want to take it up? Otherwise, 7th, I'll file my objection until.
No, for that also you need LCR. No.
Uh-huh. For that, we need LCR. We'll see it in the course of the day. Or I'll tell her.
Both sides are really represented. On the prayer made by Mr. Jahan Lal Vedipi. For the time is granted till 7/9/2023 to file objection in this interlocutory application. Next, the court master shall provide the copy of the LCR to the learned APP for perusal. List on 11/9/2023. They're giving you this LCR. You will go through 11/9 for
11/9.
7/9. You are filing your
I'll file.
objection.
11/9 matter will come.
Item 15.
We'll just note one more thing, since it is third day.
Lordship.
Uh, In the event objection is not filed, the matter will be taken up for disposal on merit.
Lordship.
Interlocutory objection. Yes. Acha, just a moment. In that, in the main appeal, right, both sides are represented. As LCR has been received, the registry shall prepare a paperwork. Like this matter, where when the connected interrogatory application is listed on 11/9/2023. Yes, yes, 31 days.
I have no objection to that because he's a legal aid counsel.
Acha. You are paying legal aid counsel. Okay. For Mr. Datta, counsel for the applicant. So the legal aid counsel for the applicant. This interrogatory application has been filed under Section 5 of the Limitation Act for condoning the delay of 51 days beyond the period of limitation in filing the collected appeal. Next one. The learned legal aid counsel has submitted that the judgment impugned in the collected appeal was communicated. To the Guwahati High Court Legal Service Committee and the State Committee by letter dated 1/9/2022 had appointed the legal aid counsel, and accordingly some time was consumed in preparing and filing of the connected appeal on 29/9/2022, and in the process there was a delay of 31 days. If the learned APP has proposed the prayer for, so it's standard, suppose the prayer for following the delay. So, however, in view of the nature of expulsion tender, the court accepts the same as good and sufficient cause for which the connected appeal could not be filed on time. Accordingly, the delay of 31 days beyond the period of the petition is condoned. Next, the registry shall now register the connected appeal, and this is the same for in the admission column.
I must say, in both the matters, I filed my objections. This office people has kept it lying. Because I remember the facts. There is another analogous appeal where I have filed my affidavit.
Time has come to drop a discipline proceeding against one more of the staff.
I should not tell your lordship, not your lordship's concern, but
No, it is,
Difficult.
no, it is, because it affects the administration of justice.
no, perfect. We gave it to them to file it and they keep with the session.
You would take it, you kind of a note to the senior government advocate. Or the delay level. Because unless one or two heads roll,
Otherwise, will not come.
last time something happened after, before 1.5 years. After that, the office was straight for some time.
Again, the same thing as us.
Again, the same
Sometimes
thing.
the civil section is okay, but the criminal section.
No, but
is
somebody must take responsibility and pen it down.
not.
If you tolerate it, that it becomes like a sale.
We'll see to it.
Ah. 16,
Item 16,
It's also a jail appeal.
Yes. Convention of delay, how many days? 40 days. You are appearing as legal counsel? Okay. Same one. Same one. Here, she will be Miss D. Bapujari. This judgment and sentence of conviction. Date of 21/1/2023, passed by the Honorable Additional Sessions Judge Vidal in Sessions Case Number 2 of 2022, thereby convicting the appellant under Section 302 IPC and sentencing him to undergo imprisonment, rigorous imprisonment for life with fine and default situation. So, the application as well as the we should simple.
supplementary item 20 for orders.
Paperwork is ready here. Yes.
Okay. Miss J. Singho, Land Council for the appellant, submits that that an interrogatory application has been filed for bail. She submits that, as per her information, there is some defect in the bail application, and she waits for some time to rectify the defects. Prayer is allowed. As Jahan and the VP, Mr. Adil and Council Correspondent 2 are present. This after. Two weeks to rectify defect.
The next time the Baba is very sad, my lord. In the office of election, ready. 28.
Before we ready, okay. This chapter will be. Just before that, you write. It is submitted. It is noted that the paperwork in this case is ready. The copy of the paperwork be served on the London Appealing Council. You also received it?
Yes, sir.
Only you have not received it. You got it.
Paperwork, yes, sir.
Okay. Service of paperwork to you also is not recorded.
But office, morning, normally we don't get the copies in the supplementary list. So morning I called up my office person. He said that it's there in the office. So I'm under the impression perhaps he has received.
It's okay. They just say that that a copy of the paperwork is served with the Appealing Council, if not already served.
No.
Just after the.
order something keep the hearing meeting with me 10 के timing is
Mr. Hallar, your other side is not there.
Okay.
Okay. Okay, just wait for some time then.
Daily list item 19 for hearing.
Yes.
What is the
Amagis, yes, yes. Ms. Ms. Jahan, my statement is not targeting. My statement is not targeting anyone special, but we want a feedback on the amicus curiae appointed, because we are finding that we are trying to rethink about the list.
This was actually prepared recently. This is modified.
No, I don't know, but we have to rethink so that existing list which is there, just give us your confidential feedback. I'm not targeting to anyone specially, but
Councils were regular and who keeps doing those names. Your lordship on this, can we suggest some names to your lordship?
give it confidentially.
Yes.
You see what is happening. We are not casting any aspersions on anyone, but at times we find that the assistance which is required is not there. The level of preparation which we expect is required to be done is not there at times. So that is what it is prompting me, because I'm only passing phase in this criminal thing, but still it appears that we should rethink. You can do it confidentially. And I don't even know whether my suggestion will be accepted or not. It's just an exercise. Want to make.
Both of us will discuss and not.
So we don't even know whether my proposal will be accepted or not. It's just a thought which just come to my mind. Yes, Mr. Tiwari.
Under 302, as well as 302. For 302, he was considered for life, and the partner is 20,000, which will be called simple request for 1 month. And in 302, he was considered for equal. In 304, he was convicted for 7 years. Because now, I don't find the FIR at page 4. The informant is the mother-in-law of the accused. Initially, there were 2 accused persons.
Appellant is mother-in-law.
Yes, informant is the mother-in-law.
Oh, acha.
Initially, there were 2 accused persons. The mother-in-law of the victim and the husband. But during the pendency of the proceeding before the London Session Judge, my lord, the accused number 2, the mother-in-law, Jalu Vishwa, she died, my lord. So, my lord, the case was going to proceed against this accused person, my lord, Vikram Bania. Now, my lord, you find the FIR at page 4, my lord. Basically, my lord, on 3 counts, my lord, the conviction has been there, my lord.
This appellant is the husband.
Appellant is there.
It was a case of suicide.
Yes. As per the appearance, concerned by it's a suicide matter, but as far as the informant part is concerned, it was a dowry there.
You have the date of marriage, 2006. What is the date?
Date of marriage is not there.
Is not there. And what is the date of death?
Date of death is 05/01/2008, madam.
1/1.
5-1.
No,
5/1.
5/1, madam. 5/1/2008, madam.
Incident is of
28/12/2007. She was there in the hospital for 7 days. madam.
Oh, acha.
28/12/2007 is the date of incident.
2007.
Yes, my lord. 6/1/2008, FI was lost. 5/1, she died. In Trivandrum, accused married 2004-2005.
Yes, Mr. Tiwari, please continue.
Page 4 is the attachment. The slide of 6 1 2003, madam. Ready, madam? Page 4, madam. I have the honor to state that about 3 years back, accused number 1 began to marry my daughter, Pulita Varsha, following an elopement with her. But after the marriage, the accused person started assaulting my daughter and assaulting with her demanding dowry. My daughter was enduring all this silently. On 28/12/2007, again the accused duo picked up an argument with my daughter with regards to dowry, assaulted her, and then set her ablaze after pouring kerosene on her. When my daughter screamed, the accused person immediately took her to the government hospital and she sustained grievous injuries. The doctor referred her to Nalbari hospital. Since her injuries were previous ones, she was referred from Nalbari to Guwahati Medical College, where she succumbed to her injuries burned around 4 p.m. yesterday, that is on 5/1/2003. I therefore pray you to investigate the matter and take necessary action. Now, my lord, thereafter, my lord, since the case was committed under section 208, my lord, so, my lord, and thereafter, my lord, in case 7, lordship will find the charge against to at least person, the charge at case 7, my lord, they were charged under 302, 304B and 34 IPC. Now, 34 subsequently got extinguished because my lord, the other accused person died. My lord. So for that, my lord, the judgment did not speak about 34 but the intention of the accused person. Now, my lord, the PW1 is a case time. My lord. The informant mother-in-law. My lord. The money position. Please, ma'am.
Yes.
I know the accused Vikram Varsha and Srimati Charu Varsha.
Oh, just a moment, just.
Please, ma'am.
Page 9.
I know the accused Vikram Varsha and Srimati Charu Varsha. The incident occurred in the year 2007. My daughter Pulita Varsha was married to accused Vikram Varsha. Their marriage took place about 6 years ago. As a result of their wedlock, she gave birth a male baby. Since after the marriage, they demanded furniture, etc. as dowry, and I have partly fulfilled their demand. After their marriage for 3 years, I have visiting terms to their residence. As I failed to fulfill their demands, as such, they did not allow me to visit her residence. On the day of the incident, I was in my mother's residence. In the entire case, there is no eyewitness. On that day at about 4 a.m., accused Vikram Varsha poured kerosene on my daughter and his mother put fire on the person of Pulita and that sent the brother of Vikram to bring me to their residence. Accordingly, I came there. I heard that she was taken to Nalbari for treatment and then I came to Nalbari Civil Hospital and came to know that already she was taken to GMCH. Then I came to GMCH to see my daughter and I found that except her face, madam, this part is very important, madam. Entire body was covered by bandage. She was unable to talk for 3 days. And after 3 days, she told me to look after her son.
Yes.
She told me that as we failed to fulfill the demand of dowry, as such, she was burnt by fire by Vikram Varsha and his mother. I was there for 7 days with my daughter. After that, I came to my residence and on that day, she died. So, my lord, she left the victim with her husband after knowing the fact that he has burned her. But, my lord, later on, I'll bring this aspect, my lord, because, my lord, even at no stage, neither she has spelled out with the doctor because the investigation in this case, my lord, was totally, my lord, not as per the standard, my lord, because neither the doctors examined who did the treatments, nurses, other attending staffs of the hospital. is no Caesar list in the case. There is no Caesar list in this case, my lord. Might be the case, my lord, since the incident was reported after she died, my lord. So for that, my lord, even if my lord, they could have tried to see something, my lord, they could not have found anything from the my lord, place of occurrence, my lord.
No, after 8 days, what they will seize.
That is what my lord.
If there was,
For that I'm saying that there was no Caesar list in fact. But my lord, as far as the doctor, attending staff and nurses, my lord, those could have been a vital witness to the incident because only on that particular statement that after 3 days, she said you. But however, my lord, I've brought the Supreme Court judgment also says that because the entire evidence on the record, my lord, does not even say that. Neither the informant in her examination or cross-examination says that she was prevented to going to the police or in any way she was restrained from informing to the police or to the doctors or the nurse or the staff, my lord. So that part is missing. But now, after that, I came to my residence. On that day, she died. After post-mortem examination, her dead body was taken to the residence of the accused, and I also went there. I filed the FIR. Exhibit 1 is the SR. Exhibit 1 is my signature. My statement was recorded by the magistrate. Exhibit 2 is my statement. Exhibit 2 are my signature. I report the same statement for the magistrate which I had proposed to him. Cross my lord. Please tell me. My husband is still alive. I live separately from my husband. While my son was 7-year-old and my daughter was 6-year-old, then we have separated from each other. It is not a fact that after separation, I have been working at different places. I know that their marriage was solemnized at Kamakhya temple and they were in love. Prior to death of my daughter, Vikram and his mother had separate kitchens for last 2 months. When I came to the residence of the accused, I heard from villagers that my daughter was burned by fire by the accused person. Now, my lord, this part is also important because none of the independent witnesses have stated about that, my lord. Neither this prosecution has brought any evidence in the case, my lord, to place the fact that any of the villagers had informed that she was burned, my lord. I do not know the name of the person who informed me that my daughter was burned by fire by the accused person. On the very day of the incident, I went to GMCH. It is not a fact that Tulika did not tell me who took fire on her. It is not a fact that I have not stated before police that Tulika told me that accused person put fire on her person. It is not a fact that I have no link with my daughter since after we have been separated. It is not a fact that for illegal gain I have filed the false FIR against the accused person. Prior to the incident, one day I went to file the FIR against the accused person regarding the demand of dowry, and sister of Vikram Bolsho told me that if I file any case and they will not allow to visit their residence in near future. After the marriage, Vikram kept my daughter at Kamakuchi in the residence of his sister, and I have also visiting terms with them. It is not a fact that my daughter burned herself and the accused person tried to save her. It is not a fact that I have falsely reported against the accused person. It is not a fact that at the instigation of other persons, I have filed this case. So my only
Ms. Bhuyan, there is a standing instructions of the state government that if there is any burn case,
Yes.
mandatory the police has to be informed.
Sure, I'm not aware of it. I'll give a call to Mr. P.P. Malaysia. With information.
Because that's a standard protocol I was told.
I know.
That, in cases of burn, it has to be reported. Just find it out.
East 26 PW2, my lord, the sister of the informant.
Hmm?
sister of the important mother. PW2 mother, Malika Talukdar mother, age 12.
Yes.
Tulika Vishwa is my niece. Imani Vishwa is my elder sister. I know the accused persons. About 7 years ago, Tulika get married to accused Vikram. While Tulika was a student of class 7, then accused eloped her and get marriage at Kamakya temple. At the time of birth of son of Tulika, I went to the residence of accused person. I heard from my sister that accused person demanded dowry from her. My sister has given Almara, Bengal, etc. as dowry. She told that while they visited the residence of the accused, then they tortured him and told her not to allow her mother to come to their residence, otherwise they assault her. Thus, after the incident, accused person burned Tulika by fire. Tulika was admitted at GMC and she was there for 9 days and there she died. I went to GMCS to see Tulika, but Vikram did not allow me to see Tulika. Then I returned to the residence. Police recorded my statement. At the time, at the time of incident, I was at Pathsala. It is not a fact that I have not stated before police that I have heard from my sister about the demand of dowry. It is not a fact that I have not stated before police during investigation that when I went to GMC, Vikram did not allow me to see Tulika and I went to Guwahati to see Tulika. Tulika was in love with Vikram but accused has quarreled with her prior to her marriage and this fact was stated to me by my sister. It is not a fact that I have not any knowledge about the incident that at the interest of my sister, I have falsely deposed against the accused person. My sister told me that Tulika told her that accused person burned her by fire. Our my lord, the evidence of PW world, my lord. It has not come that the sister came up, she was not allowed to visit. However, on her own statement, my lord, the PW statement is there. Throughout 7 days, she was there in the hospital, my lord. So no any evidence is not on record that the sister was not, and that apart my from their reading of the PW2 matter. She is only an hearsay evidence because she has reiterated a statement by saying that my sister told her, my sister told. She did not have any personal knowledge about any dowry or my lord, any cruelty or harassment or torture method on the victim. That is not. Now, my lord, PW3 my lord. He's an independent witness, my lord. He's a teacher of the in the
Yeah, I'm showing you this.
I know.
This is from the website of National Health,
I know.
the moral duty.
Suspicious burning is social as well as not. Yes, ma'am. It's there. I have talked to Mr. PP before you get the information. Yeah, GTN have found somewhere, worship.
GDNT is 771.
with respect to the postmortem, because at the Bhagar police station, after the death, the Bhagar permission was taken for postmortem. Their
So the GDNT is relatable to postmortem only.
only for the purpose of postmortem.
Because I have read somewhere, there is a reference to a GDNT
I know.
somewhere. I won't be able to locate it right now. But
Page 14, my lord, is a teacher, my lord. Now he says, I have seen complainant Imani Vishwa today only. Now the neighbor says that he has seen the informant today only. At least so that if somebody is visiting her daughter's place, my lord, at least the neighbors would be knowing that, my lord. I knew her daughter deceased Tulika. I know the two accused person. The incident took place about 4 years back. Tulika was married to accused Vikram. They got married following a love affair and a male child was born to them. On the following day of the occurrence, I came to know that Tulika got burned and she was taken into hospital. After a few days, she died. Police asked me about the incident. I am a teacher. Accused Vikram was my neighbor. He was on rent. I know about their love marriage. I was not in visiting terms with them. I do not know about their private life. I do not know about the quarrel between them. I do not know who had taken her for treatment. Vikram performed the last rites of the disease. I do not know where Himani Vaishya lives. So, my lord, even had there been any sort of cruelty or subject to Himani mental or physical torture, my lord, the neighbors would have been, my lord. And he, being a teacher by profession, my lord, he would not have lied for the court. So, meaning thereby that, my lord, the one part of 304B, my lord, soon before her death, she was subjected to cruelty, my lord. That is not from this independent witness, my lord. Now, my lord, page 16, PW4, my lord. My lord, this is Usha Soiveri, my lord. She is a housewife, she is a neighbor, my lord. I know Himani Vaishya. I also know Tulika and know the accused duo. Tulika was married to accused Vikram and they had a son. I do not know about the incident. I heard that Tulika had died. Now, my lord, in the cross part, she says, I have heard the name of Himani only today. Again, my lord, she speaks about the informant that today only I came to know about her name. She stays in
Correct.
her mother's house.
Every day I meet lawyers, I record their names, and maybe perhaps in the same day, I will ask the name twice, and I'll say that I have heard the name. No, in social causes we don't know. We will not know the name. There are many relatives of whose when we hear about their good name, we don't even identify them. But somebody calls about their home name, then we remember, oh, this is that fellow. But you ask the what you call the good name, I may not be able to know many people.
But I don't have the privilege of meeting thousands of persons.
No, not that. Not that. It's a usual thing I'm saying in a family. We call people by names. We remember those names, but a good name. I may not remember. I may not even know.
He used to advise us, if you want to be a lawyer, first you have to recognize, while practicing, recognize the lawyer's name, my God.
No, that is true. But you see, what happens is that here, when we are concentrating in this documents and papers,
I know.
we tend to forget the names.
Yes, yes, happens.
It's not that intentionally I'm not remembering your name.
Yes.
And it is so happening that when I'm concentrating here, the names just doesn't get registered.
Lordship, so,
The mind has been left.
so many names your lordship has to recollect.
No,
Lordship.
you see, when you said about the GDNT, I remembered the GDNT
Yes,
because I
it's
read
there
it
in
somewhere.
our chart.
No,
chart,
whatever
yes,
be,
yes,
but I remembered that.
yes,
So what is relevant to me, I remember.
yes.
But names somehow it doesn't. I just can't remember. It's a bad habit, but I just can't
It
remember.
happens. Ritual.
I'm weak there. To
Your
remember
lordship
names.
is not.
No. To remember names, I'm weak. I just forget the names.
Now, Madam, the cross faxi says that I have heard the name of Himani only today. She stays in her mother's house and not in the house of her husband. Meaning thereby, mother, this independent witness had talking terms with the disease. That is why she knew that her mother is separated with her father. She is staying there.
No, this Himani is the first informant.
Yes, she is the informant.
So he's saying that Himani lives with her mother, not with her in-laws.
Not with her in-laws, whether she stays with
Her own
her
mother.
mother. Now, PW5, page 70. He is also an independent business fellow. His name is Sadhu Das. But my lord, here it is blank, my lord. I have taken this name from the judgment, my lord, because page 35 of the judgment, page 35, my lord. The name of PW5 is referred as Sadhu Das. But here,
No, because you see, in the down below you'll find LTI of Sadhu Das.
yes, there also.
Hmm.
Now, my lord, this witness has only stated that I do not know Himani Vaishya, I do not know Tulita also, I do not know about them. हमारा PW 6 में in this type it won't be a file as per the version of the information. PW 6 page 18. I wrote the exhibit 1 FIR as per the version of the information Himani Krishna, and I read over it to her, and finally she put her signature on it. She accepted the FIR as corrected. Exhibit 1 is my signature as slide. Now my lord, PW 9. PW my lord, 7 my lord, page 19. Now she is the doctor who conducted the postmortem. Okay, this is 15 my lord. Edit my lord. On 6/1/2008, I was working as demonstrator in the Department of Forensic Medicine GMCF at Guwahati. I conducted postmortem examination on the dead body of Tulika Bania, age 17 years, female, Hindu, wife of Sri Vikram Bania, village Hindu, ward number 1, who is identified by UBC Vijan Das, HG Asharuddin Ahmad and Vikram Bania in connection with GMCH OPGT entry number 63 dated 5/1/2008 and found as follows. On examination, a female dead body of thin being found wearing a pink petticoat, chest wall, both arm, left lower leg and ankle are covered by roll bandage. On examining the bandage, burn injuries are seen over the front of chest, upper part of abdomen, both arms, neck, face, part of her hair, left leg, vertical, hips, back of chest. Burn areas are blackened. The injuries are dermophysical and deep in nature. Patchy areas of pus and granulations tissues are seen at places over the burn injuries. Thin line of redness is seen between the healthy tissues and the burn injuries. Bones are unhealthy and foul smelling. On examination of chest, feel as described, hips and cartilages are healthy. There is muscles, thorax and tehera pain. Both hands are pain. On examination of abdomen as described, peritoneum, mouth, pharynx, esophagus, stomach, intestine, pain, grave ventricle, small intestine, of course, contains juicy materials and gas. Large intestine contains facial materials and gas. Organs of digestion, external healthy, uterus healthy, empty, skull and vertebrae are healthy. Membrane is pale. Spinal cord not examined. Death was due to exhaustion as a result of burn injuries as described. All the injuries were anti-mortem and dermophysical too deep in nature, covering approximately 60% of total body surface area. Time of death is approximately 12 to 24 hours. Exhibit 3 is the postmortem. Exhibit 3 is my signature. Exhibit 4 is interest report of disease source. So my lord, 60%. Now there are certain 90 to 95% per day. 15 can speak, but there are certain judgments also that say that like one is 15 might speak, 15 might not speak. But there are however, I think hearing this case, as far as torture or any other injury apart from burn injuries, not seen. The other way around, only also on account of burn injuries, but the other external injuries cannot be seen. But PWP, in this case, altogether.
Just one.
4 numbers of
Just-
files.
Who is Usha Swargyari?
She is PW4 mother. She is a housewife mother.
Hmm?
Housewife.
PW4.
Not related to the victim or the informer mother.
Hmm?
She is not related to the victim or the informer. She is an independent witness otherwise.
What did she say in her evidence?
She said that I know Himani Veshya, I also knew Tulika and know the accused duo. Tulika was married to accused Vikram and they had a son. I do not know about the incident. I heard that Tulika had died. I have heard the name of Himani only today. She stays in her mother's house, not in the house of her husband. In the cross she stays. I have heard the name of Himani only today. She stays in her mother's house, not in the house of her husband.
Body was taken at 164. Just the police could see.
Which one? Let's see which one.
Mother to 164 recorded as
No, no,
72
just-
mother of Himani.
just-
Yes. Usha Swargyari, and she said that not seen anything.
Next to GS. Exhibit. Okay.
Ah, yes.
PW page 21 is the officer in charge of the Bhanga police station. But he only did a GDMP and sent the dead body for postmortem. Looking at page 21, under Rajneesh Singh. On 6/1/2008, I was in charge of Mahathir Puri attached to GMCH. On 6/1/2008, I sent the dead body of Mrs. Purita Bharna, aged over 70 years, wife of Sri Bharna of Tihu Town, ward number 1, Dalbari, by a dead body challan for postmortem examination by the doctors of the Department of Medicine, GMC White, GMC OPD, GPET number 6/5/2008. I sent the dead body challan along with the inquest report. Exhibit 5 is the dead body challan. Exhibit 5 is the signature. PW 9, page 22, madam. SI Rukini Kumar Talukdar. On 1/8/2008, I was working at SI of TUPS. On that day, OC TUPS handed over the case diary to me to complete the investigation. The earlier IO was SI Tapan Kolita. During the investigation period, I arrested accused Vikram Bharna, Vikram Varsho, and forwarded him to London CJL. The other accused could not be arrested during my investigation period. I also recorded the statement of witnesses, namely Naveen Sharma, Mahendra Nath Varsho, HR, whose name is Monikanta Talukdar. I also recorded statement of 2 witnesses, namely Himani Varsho and Usha Swargari, under 164 by magistrate. As I was transferred, so I handed over the case diary. Thereafter, I knew the signature of O.C. Mehta Dalta. He expired. I submitted charge sheet in this particular case against the accused Vikram Varsho and Jalo Varsho under section 304(34) IPC. Exhibit 6 is the charge sheet. Exhibit 6/1/623 are the signature of the O.C. Nandara Kota, which no defense loss was declined by. PW 10, page 23.
What is the name of the mother of the appellant?
Money.
No, the mother of the deceased.
Money,
But-
PW1.
PW1, Himani Varsho. Yes.
PW10 Siratul Haq, madam. On 5/8/2009, while I was working as TU as SI on that day, OC TUPS handed over the case diary of TUPS case number 1 of 2008 for completion of the investigation. On perusal of the case diary, I found that the investigation is almost completed and only accused is to be arrested. I searched for the accused but could not trace out him. Thereafter, I was transferred and I handed over the city to OC TUPS. And also, my lord, the cross was declined, my lord. Now, PW 11, my lord. Upon Kulta, my lord. It's also one of the IO case, my lord. The FIR was registered while he was in charge. On 7/1/2008, while I was working as OC TUPS, on that day, I received an HR from Himani Varsho and registered the TUPS case number 1 of 2008 under section 304 IPC. And I myself took the charge of investigation. Thereafter, I recorded the statement of the informant Himani Varsho at the police station and visited the PO, which is the house of the deceased and accused superior ward number 1 of the wife of Tihu Town. I prepared the sketch map of PO. Exhibit 7 is the sketch map. Exhibit 7 is my signature. I recorded the statement of 2 witnesses. From the witnesses, I came to know that the occurrence of setting fire happened on 28/12/2007 at night. And the victim was shifted to GMC, and on 5/1/2008, the victim expired at GMC. In the meantime, I was transferred, and so CD was handed over to the post. Now, my lord, cross, my lord, page 25, my lord. The occurrence happened on 28/12/2007, and the Aadhaar was brought on 7/1/2008. As I was transferred on 7/1/2008, on the same day he was transferred also. So I did not visit GMCH. I did not seize any article. Witness Himani Varsho during her 161 statement disclosed that accused and the victim used to cook separately. Disclosed that accused and the victim used to cook separately from the mother of the accused. Witness Monika Talukdar, my lord, PW2, my lord, during her 161 statement revealed that she did not state that she heard from her sister that accused demanded dowry. So my lord, here the IO says that PWT who never said that I have heard from my sister that the accused is to sit down and they make a sort of 12 years. So my lord, hearing only on statement of informant PW1 that after 3 days the victim said that you take care of my child and that since people could not fulfill the dowry demand, I have to burn. So my lord, this is the only statement by which this accused person has been convicted. Now, my lord, the Lord should appreciate. I'll just take the 313 thereafter, my lord, I'll place my argument. Now, my lord, entirely, my lord, 313 starts from page 27, my lord. Here, my lord, all the questions the accusers denied, my lord. Only page 30, my lord, the last. If I write down the numbers, my lord, for my number it will be 15, my lord. Page 30, my lord. Last about the questions, my lord.
Yes.
Do you want to say anything else? Here, my lord, he says, I am innocent. On the morning of occurrence at about 5:30 to 6 a.m., I went out of my house to answer natural calls as well as for taking bath. While I returned back from bathroom, I noticed that the door of my room was locked from inside. While I looked through the window glass, I noticed that Tulika was roaming inside the room. After opening the door of the room, close to you, I noticed that Tulika was burning. There was no other person except the 2-month-old baby and Tulika inside the room. So I presume that it was Tulika who herself set on fire her body. I immediately brought her to the hospital. So, my lord, this is the explanation which the accusers made by the since, my lord, generally it is seen that in the village areas, my lord, they generally go for natural cause somewhere, place somewhere out of their house, my lord, for a distance. My lord. Now, my lord, the second part which I will place before the lordship is that the feet, my lord, the lower part of the body of the victim is also not seen to be burnt. And my lord, if he sees from the window, he has seen the feet, my lord. Those were running inside, meaning thereby that if she's running, then to presume that something has happened. This part is, and the house was inside there. Now, my lord, the landed court below, madam, has convicted the accused person under 304B and 302. Now, 304B is also read with 113B of the evidence. The main ingredients of 304 is that the death of a woman must have been caused by burn or bodily injury or otherwise than under normal circumstances. The first part says P, and the second part is that the death must occur within 7 years of marriage. So now, even if we see the prosecution evidence, the death occurred within 3 years of the marriage. But soon before her death, the woman was subjected to cruelty or harassment by her husband or any other relative of her sister. Now, this part of the evidence, the prosecution failed to lead to the actual court. Because of the fact, only PW1, none of the independent witnesses, my lord, have stated about any quarrel or about any demand of dowry. That apart, my lord, when this informant gave the dowry articles, that also she has not brought on record in her evidence. After 1 year or after 3 months of marriage, after 2 years of marriage, that part is not there. And the fourth one is that, my lord, such cruelty or harassment must be for in connection with demand of dowry. Now, my lord, the PW1 have stated that I have fulfilled some of the demands. But PW2 says that Almari and bangles, my lord. This has come from Monica Talukdar. However, the PW1 have not even stated about any of the articles which she gave to her daughter if there was any demand of. However, madam, the PW2 in their evidence, madam, have stated, madam, that yes, my sister has given Almira and Bengal, etc. as dowry. However, the PW1 money did not. So, my lord,
Take a break and come. By the time Mr. Tiwari is coming, apparently, so far as the evidence which he has read, 304 part, 304B, that ingredients we are not finding is there.
The 164 statement of the murder of the victim. 28/2017, there was a demand.
No, that is our own statement. You see, then I just in a letter to me, I am saying, I go to the magistrate, get a statement recorded in the 164, some crime has occurred. I go and record my statement as 164, and I claim that the Taj Mahal belongs to me. Correct. Then I swear an affidavit. I say that Taj Mahal belongs to me. Now I exhibit this document. What is the evidentiary value? Will give me the ownership of Taj Mahal if it's
No, the
happens.
164 statement is not a substantive piece of evidence.
So
It is for corroboration for contradiction.
No, therefore, it is her own statement. So a solitary statement. Nobody has come forward to say
Yes.
that the demand of dowry was made. That is one part. Second part is that 302 remains. Supposing we discard 304B, then 302 remains. Now, here also, the victim died after 7 days. Had the husband burnt her, she would have disclosed that to some man, some person in the hospital. The doctors will always.
Was she meant to say there is no dying declaration?
No, not that, not even that. I'm not suggesting that. What I'm saying is, you see, for some reason I am hospitalized. What will be the doctor? What will be the normal course of a doctor? He will ask the patient what had happened, why you had come, what was your trouble. Do you think that doctors in the Guwahati Medical College and Hospital are so without empathy that they will not ask the patient how she got burnt? It's unnatural. If the doctor doesn't ask, it's an unnatural conduct. Because the doctor will ask, how did it happen? It's a normal question which the doctor will ask. And he is required, under the rules of practice, to record the history.
Yes.
If a doctor doesn't record the history of a patient, then he's not abiding by the code of conduct. It's a misconduct, in fact, the doctor not writing a history of the patient. So therefore, and the second point which has struck us from the submission of Mr. Tiwari is that the husband had an opportunity of murdering the wife on the day of occurrence. The wife got burnt, and it is he who has brought her to the hospital and
He was
treatment.
on it, yes.
So therefore, if the wife wanted to implicate the husband of murdering, making an attempt to murder her, she would have reported it to the doctors there and then.
So for 3-4 days she was unconscious. At the time.
No evidence to that effect that she was unconscious.
Yes, the PW1, evidence of PW1.
So that's the difficulty.
Except evidence of PW1, there is no.
So you
one
see,
evidence.
so the police does not even seize the bed ticket of the patient that she was, no, she was unconscious for 3 days. Would be a thing which will be recorded in the docket.
Molecular record, but it was not exhibited, Lordship. It's not a.
No, I have tried to find out. It was-
Madam, on similar language of Watson is placing, madam, I'm placing the judgment of 2014 7 SSC 405. I placed the judgment, madam, para 23, madam. Came from the lordship, para 23 of the judgment. madam. This is authored by my lord. Justice. Then my lord, Chitrasi Media and the judgment. Para 23, madam. Last page, madam. 18. Para 23. The other circumstances which draw our attention is when the deceased informed their parents on 6/8/2003. It is quite natural that the parents will inform the police about the incident because it is nobody's case that they were restrained in any manner from informing the police. Even the deceased throughout the stay in the hospital for those 11 days had many occasions to meet the doctors and other staffs of the hospital, but she has chosen not to give any complaint, nor try to share her agony with them, which throws a grave doubt on the genuineness of the dying declaration. She died, madam. In this case also, the victim died, madam. But throughout 11 days, she did not spell out a single aspect that the husband or in-laws have burned her. So, madam, in this case also, madam, the similar circumstances are there. For 7 days, madam, the victim was there in the hospital, madam. She did not even speak anything, madam. There would be a curiosity, madam. Because the doctor would definitely will try to know that what has happened to her. Either it might also be a case that my lord, she was unable to speak out. Because in this judgment also, my lord, the Honorable Supreme Court has taken note of, my lord, the judgment.
No, that itself is ruled out because if you accept the statement of the PW1,
Yes,
then the victim did speak.
yes,
So that she was unable to speak is ruled out.
it's ruled out.
For 3 days, Lordship. For 3
No,
days she
no,
was
Only
unable to speak.
initial
No,
feelings,
no.
madam.
You see, in the absence of evidence, this must be a positive evidence because there can't be a negative evidence that somebody could not speak. There has to be a positive evidence that she could not speak.
Apart from Lordship, apart from PW1, doctor also did the same.
If you understand that,
Lordship.
supposing in the court, you are arguing before this bench, and we are not reacting to any of your statement. You say that the honorable judges were silent. We could not. We had no opportunity to interact. We never understood what was there in the mind of the honorable court, and therefore, you are saying that the court was silent. But this has to be a positive evidence only. By inference, you can't say that the court was not interacting
Lordship.
or the court was not conscious of what was being argued. We were as if I was arguing before a wall.
Yes.
Correct. So therefore, there can't be a presumption about the conduct. There has to be a positive evidence. That is what the point I'm trying to make. The example was horrible.
No, it was-
Because he died after 7 days.
Yes, they could have recorded the dying declaration. Treating doctor could have recorded the dying declaration, nothing is done. Your Lordship.
Magistrate
So that's
magistrate
my
could have been
Yes.
requisition.
My lord,
It's not there that there was imminent threat
yes.
to the life, and that she was not in a capacity to speak. Because that also the doctor will say
Yes,
that on the day when the PW1 was interacting with the patient, she was in a position to speak. Because this statement was taken, this so-called dying declaration, oral dying declaration, is made in absence of anyone.
Yes.
No independent witness is there. And you see, the conduct of the mother is, if PW1 is the mother, that is one of the most unnatural conduct which she will make. Her own daughter, before dying, is saying that she was burned by the husband. And she digests that information without raising any UN cry, not making an issue out of it. Because supposing I come to know about something which has happened, I would definitely confide it to someone.
No, PW2. PW2 is the aunt of the.
In her 161, she says that it's not there because she is denied. No. In the PW2, she denied the PW11.
Stating before the police.
I have PW11. He says that last line. PW2 did not say before me that his sister told.
Sister told me that Bhumika told her that this person is part of the fire. She was informed by PW1.
That's okay. But before the police, PW2 doesn't say.
I have not checked 161 statement.
Huh? It's just a story. This is, yeah. You see, long back, about 10 years back, not even 10 years, I think it will be 10, 12 years back. At that time, in the Latasin field, the net was not there between the car parking and the in the field.
Yes.
There was no net.
Yes.
So one day a cricket ball came from the field, hit a car of the learned lawyer, and it was the car windshield or side glass was broken. So after the court house, when we or in the afternoon, I don't remember, when I was out, my driver was telling me that the ball came, made a sound, shoo, and then it hit the car and then it broke. So I said that, well, when you were so close that you hear the sound of a ball, you could have caught it. He said, no, sir, I was a bit back. Then how could you hear the sound? Then he understood and said that, oh, sir, you have started cross-examining me. No, I did not see it. He said that he heard from someone that the ball had come and. So you see, if a ball, just telling a story, you see a cricket ball, somebody hits. You watch, you've seen the ball coming. So normal tendency, man, even if he doesn't play, tendency would be to catch the ball. That's a human tendency. I'm just making a comparison here. Because if somebody tells a story, the girl before dying tells her mother that I have been burnt, how can a mother remain silent without informing any third person that what has happened? You see, it's not her case. That when she told, immediately thereafter PW2 came and she confided. Because in the hospital, the nurses would be there, ward boys would be there, doctors would be there. And she is a burn patient, she will have more care than others. In a burn. No, I don't know. I have not seen those cases, but when it's a one case, she will have more attendant than one doctor or nurse attending her. That's what I understand. Because the doctor's evidence that it is 60% burn.
The general ward of GMC, so much of care.
I think general ward would be better than private ward in any hospital.
General wards, sisters remain, but lordship for one patient, one sister like that.
I'll tell you, it's my experience. My mother was operated twice, and at both time at her instance, we kept her in a general ward. And everybody in the family was annoyed. Why should I keep my mother in the general ward? But my mother said that she doesn't want to live in a closed room,
Secluded.
secluded. So she wanted, at her choice, she wanted a general ward. And we had no complaint that she was never taken care of.
No, no, no.
Because in a general ward,
Yes.
there are more than one attendant. So in a private ward, you may not have the attendants. But in the general ward, at any given point of time, you have an attendant.
I need to say, one person, one attendant, that is not there.
So that
But your lordship, the doctor service is better in general, in the GMCH, your lordship, compared to other hospitals. Because 24/7 days, even one patient is shifted to cabin, then it takes time. So, my experience is this.
No, it's still a perfect- that's what I'm saying, because it's quite unnatural. The mother will hear somebody has banned her daughter and she doesn't react.
May I take the lordship statement of Monica Talukdar? মোৰ নাম ঠিকনা কোৱামতে সত্য হয়, মই এজনী ঘৰুৱা কাম কৰা মহিলা হয়। মই তুলিকা তেওঁলোকক চিনি পাইছিলো। আজিৰ পৰা প্ৰায় 3 বছৰমান আগত তাই বিক্ৰম বৈশ্যৰ লগত বিয়া হৈছিল। মই জনাত বিয়াৰ পিছৰ পৰা তুলিকা তেওঁৰ স্বামী আৰু শাহুৱাৰ শ্ৰীমতী জালু বৈশ্যৰ শাৰীৰিক আৰু মানসিকভাৱে অত্যাচাৰ আৰম্ভ কৰিছিল। আজি সময়ত তাৰ অত্যাচাৰ থাকিব নোৱাৰি মাকৰ ঘৰলৈ কেইবাবাৰো গুচিও গৈছিল, কিন্তু মই লগতে আনন্দ লোকো তাই বুজাই বঢ়াই পুনৰ
You see, just I'm stopping you here, but then her statement would be a false statement. Because mother says that for 3 years she was not allowed. Her marriage was 3 years before.
Yes.
So after her marriage, she was not allowed to come in the home. So evidence of PW2 would be false. Here it says that because of the torture, she came home.
Yes.
But her own mother says that she was not allowed to come home.
No, I think she was not allowed to visit.
That has come from the informant that my sister was not allowed to
Imani
visit.
PW1 was not allowed to visit
No,
the
PW2.
matrimonial home.
No, see that.
That may be wrong, madam.
First,
Should I
you said that
complete?
you don't come to my house, otherwise you will be assaulted. Now
Should
that
allow
statement has come.
May I complete her statement? মাজে সময়ে তাই অত্যাচাৰ থাকিব নোৱাৰি মাকৰ ঘৰলৈ কেইবাবাৰো গুচি গৈছিল, কিন্তু মই লগতে আনন্দে তাইক বুজাই পৰাই পুনৰ গিৰিয়েকৰ ঘৰত থৈ আহিছিলো। মোৰ সময়ত এদিন তাইৰ স্বামী আৰু শাহুৱেকে মাৰপিট কৰিছিল মোৰ সন্মুখতে আৰু মাৰি পেলাব বুলি ভাবুকি দিছিল। গতিকে মোৰ কব হয় যোৱা ইংৰাজী 18-12 তাৰিখে তুলিকা বৈশ্যক তাইৰ স্বামী আৰু শাহুৱেকে হয় মাৰপিট কৰি তাত কেৰাচিন তেল ঢালি জুই লগাই দিয়াটো সত্য হয় আৰু চিকিৎসা অৱস্থাত যোৱা ইংৰাজী 24 তাৰিখে তুলিকা মৃত্যু।
But this statement is
Lordship,
not
may I
there in
take
the-
your lordship to the evidence of PW1?
Yes, yes.
Lordship, 6th line. After their marriage, 7 line, page 9. After their marriage, for 3 years, I have been visiting terms to their residence. As I failed to fulfill their demand as such, they did not allow me to visit their residence. It's regarding visiting the residence of the husband of the victim. On the day of the incident, I was in another's residence. So, Lordship, they were visiting terms. Visiting term was restricted, Lordship, after 3 years. As a way to fulfill their demand as such, they did not allow me to visit their residence.
Yes.
So after 3 years, Your Lordship. And one more aspect, Your Lordship, is Sunday, no. So she is having a small child, my lord.
2 months old baby. By the time she-
General Lordship, generally mother will not think over before committing suicide, harming herself, but she will think about her child.
Okay, let's try to complete his part.
As far as 304B part is concerned, my lord, the dowry part, my lord, the evidence is short for us. And soon before her death, my lord, that part also, my lord, is not there, my lord, because, my lord, when did she give the news articles, my lord? That is not from the evidence, my lord. That apart, my lord, she had full confidence upon her son-in-law. That is why she left the hospital and came to her residence. Because her husband was taking that much care also, whatever was required in the hospital, that is why she left. On that day, she died, my lord. Meaning thereby, and by that time, my lord, the judgment which I have placed, my lord, it is not the case of the prosecution, neither of the PW1 and 2 that, my lord, they were restrained from informing the doctors, the other staffs, as well as the police, my lord. And in fact, my lord knows that in the hospital itself, my lord, there are police officials, my lord. And that apart, just coming out of GMC, while entering or coming out, my lord, will find a Bhangad police station is there, my lord. Before I enter the hospital, my lord, I'll see the police station, my lord. And it is not their case that anybody has prevented them from doing so, my lord, to informing the police, my lord, about the incident.
Lordship, one more factor, I leave it to your lordship, although it goes against the person. This person also was present at the time of the inquest, my lord. Inquest report says.
So prior to postmortem, mother request was done, and thereafter postmortem was done. So he would be there because her mother
His
came,
signature is there.
his signature is there, because only after the last rites were done, mother, thereafter FIR was filed.
Oh, okay, I get it.
The second part of my argument, another argument, had there been a dowry death, mother, or there has been a demand of dowry, mother, the independence, any one of the independent witness could have spelled out that part, mother. So, mother, the entire evidence is silent on that aspect. Only even the, my lord, the 3 IOs who are there, my lord, they have also stated, my lord, they have stated that whatever has come from the informant only, not from any other witnesses. That is why, my lord, the other 2 well, aspects which were taken over by the London session judge were that, my lord, circumstantial evidence and, my lord, 106, my lord. Last in theory and, my lord, proper explanation under 106, my lord. However, circumstantial evidence in 106, my lord, I'll place one judgment of the Honorable Supreme Court, my lord. At least, my lord. Because I take a lordship's judgment only after I place my judgment. It's only 3 or 4 paragraphs which has been taken care of, my lord.
Just tell me what is the place of that burning? It is the house of whose house?
My lord, as per the, it's the house of the accused only, my lord.
Lordship has seen the
As
sketch
far
map.
as this sketchmap is concerned, madam, I
Is
just.
89. Seems to be open space, my lord. Rooms all around.
Rooms all around.
No, whose house is not stated.
Now, PO is A, Lordship. A indicates the place of occurrence where the accused person named the exam one Tulika. Lordship, he says like he from the window.
No,
he-
please come to page 11. I'm asking for a reason. Yes. Second para, last 3 lines. After the marriage, Bikram kept my daughter at Kamarkuchi in the residence of his sister, and I have also visiting terms with them.
Lordship. But here, the mother-in-law also used to stay by them. Parents' room is also there.
He is shown as the parents.
Because Lordship, other accused who has subsequently expired, she also is a co-accused, my lord. So she was also there. So it was
Okay.
So Lordship considers this part, my lord. So opens this view. Doors and windows all around. His submission is he came from outside. His submission is that he came from outside. Accused versus person under 313. So Lordship, from window he watched this one victim loitering here and there. But there were Lordship other areas are also there. From where he could have entered upon.
But interestingly, my lord would also appreciate that in the entire sketchment, there is no any indication of a bathroom.
But yes.
Means he has gone out. This also indicates that part. my lord. Had there been a bathroom shown in this sketchmap, then it is presumed that he could have used that one. But it's not there in this sketchmap, means he has gone.
Gone out, but entering, there were Lordship three squares have been shown there, Lordship. Lordship, so he could have easily entered there, my lord, which he did not do.
No, we don't know where is the entry. We don't know.
Lordship's nothing is indicated.
Where is the entry? We don't know. But you see, there is a veranda where there is an entry shown.
Yes.
So therefore, this what you call this 3 squares which are there, we don't know what is there. What is that? It may be Almira because the second in this in the western side,
Maybe some.
western side where you find a wall,
Yes,
and this square is beyond the wall.
my lord.
So we don't know what is it.
Maybe
We
Almira
can't-
standing there.
we don't know. We can't presume.
My lord, the neighboring houses are also shown, my lord. He indicates the house of Kamleshwar also. Then he shows the house of, my lord, Province Swagari, my lord. F indicate the house of Savitri Gosho, my lord. So the nearby people are there, my lord. But none of the independent witnesses said out anything against this accused person. That there was any demand of government. But that's because that part is just said.
He also presumes Tulika, who, I presume that it was Tulika who herself set fire on her body.
Hmm?
According in the 313 statement, at page 30, accused person presumes that it was Tulika who herself set fire on her body. They believe.
Also locked from inside. Yes, forcefully broken the gate and entered, my lord.
So all these three neighbors were not examined.
Not examined.
One big Narayan Chandra Sharma has been examined. PW3
But Narayan Sharma's house is not shown here
shown
in
in
this
the sketch.
sketch.
But my lord, Provin's wife has been Usha Swigeri, who is the Provin's wife. PW 4 my lord, page 16 my lord.
Ah,
She is the wife of Provin's Swigeri.
acha, wife of Praveen.
Yes, ma'am. PW 4 my lord.
His house is E, backside.
Yes, ma'am. Yes.
Okay. Yes, Mr. Tiwari.
My lord, this second, my lord, the other two counts were my lord, circumstantial evidence and 106 my lord. Reasonable explanation from the accused my lord. And these circumstances leading to the death my lord. So these two aspects were taken by the accusation there. Welcome. So my lord, I placed the judgment reported in 2022 7 SCC 443 my lord. Hearing the living judgment of Sharad Vijitan Bhutin, Sarada is also taken up. The payment. Para 26.
Yes,
Para 26.
para 26.
26. This I am referring for last scene and my lord 106 also my lord. And para 22 will be relying for circumstantial evidence. The same judgment. Internal page 11. Once the theory of last seen together was established, the accused was expected to offer some explanation as to under which circumstances he had parted the company of the victim. It hardly needs to be reiterated that in the criminal jurisprudence, the entire burden of proving the guilt of the accused rests on the prosecution. Nonetheless, if the accused does not throw any light upon the facts which are proved to be within this special knowledge in view of section 106 of the Act, comma, such failure on the part of the accused may also provide an additional link in the chain of the circumstances required to prove pregnancy. Of course, section 106 of the Evidence Act does not shift the burden of the prosecution on the accused, nor requires the accused to furnish an explanation with regard to effects which are specially within his knowledge. Nonetheless, furnishing or not furnishing of explanation by the accused would be a very crucial fact. When the theory of last will together as provided by the prosecution is to know as to how and when the accused started the company of the victim. But my lord, hearing this case, the reasonable explanation has come up. Now, my lord, the last scene will not come in play because of the fact, my lord, thereafter, my lord, had he committed the crime, he could have fled away, my lord. But taken down somebody who has 60% burned to the hospital, staying there for 7 days, No, I mean, prosecution witnesses come up and say that he tried to avoid the hospital. He was roaming outside. He was never coming inside. He was not taking care of the victim. Then could have spelled something different, my lord. But he was all along there, meaning thereby that he was ready to face any consequences. Meaning thereby, had the victim said that he is the culprit, immediately he could have been arrested, my lord. So it is not that he was fleeing away or he was not there with the victim for 7 days. If I am there with my wife for 7 days, so my lord, in order to get her cured, I am there for 7 days. And that apart, my lord, if I have done something wrong, then I'll be at a risk that if she says something against me, I'll be put behind the bar. So that risk has not been shown in the prosecution witness, meaning thereby that the theory of 106 my lord will not come into play because as rightly come up from your lordship that I have taken her to the hospital. And the PW1 says that initially to Tihu Civil Hospital, then to Nalbari, and then to GMCH. My lord, they could have even by the time initially she was making hue and cry, my lord. Then at Tihu Hospital, she could have spelled out something, or at Nalbari. Might be that while bringing to Guwahati, she became unconscious, my lord. But that aspect also, the IO or neither the prosecution witness to bring on record that she has spelled out something, my lord.
He was first brought to Tihu.
Yes, sir. As per the PW1's evidence, initially she was taken to Tihu. Thereafter,
Tihu where? Tihu. He says Tihu.
No, the FIR is there in the FIR, page 5.
Just tell me. See,
Compared to Tihu Government Hospital.
Tihu Government Hospital.
Government.
Tihu does not have a government. CHC should be. Then to Nalbari.
And she sustained grievous injuries. The doctor referred her to Nalbari.
Nalbari to them to Guwahati. From Nalbari to Guwahati. He meant to say maybe from Tihu to Nalbari to Guwahati.
No.
And
So
from
it confirms that so far 30 what do you call this? Then it discloses 302 and 304B because even in unbelievable that in Tihu Government Hospital nobody will ask the victim. In Nalbari she will not be asked, and in Guwahati she will not be asked. And the husband is accompanying her
Yes.
all throughout.
and the mother is not there. PW1 is not there by the time. Till
No, she was informed by the brother of the accused person.
Right?
And they have
This check is
That's okay.
because he has not hidden the incident. Immediately he has sent his brother on the very same day. Call her mother. Had he had hidden money, he had done the offense.
Did it finish?
No, hearing this case also, the accused mother did not hide the incident. Whether he sends his brother, a responsible person, to the mother-in-law to inform her about the incident on the very same day. Now, para 22 of the judgment. Therein, my lord, the judgment of my lord is Sarat Vijay Sarkar, state of Maharashtra.
Yes, please continue.
My lord, page 9, para 22, my lord.
Of this same judgment.
Same judgment.
Yes,
Para page 9, my lord.
Yes.
Para 22.
we are there.
Well, I start from the 7th line. Well, the 5 golden principles laid down by this court in the case of Sarat Vijay Sarkar versus State of Maharashtra, reported in 1984 to SCC 116 and followed in credit of are both equally. A close analysis of this decision shows that the following condition must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may not be that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji Savrao Bhogde versus State of Maharashtra, where the observation was made. Certainly, it is a primary principle that the accused must be and not merely be guilty before a court can convict. And the mental distance between maybe and must be is long and divides legs, congestion, and sure confusion. Number 2, the facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be extendable on any other hypothesis except that the accused is guilty. As what rightly came up from the lordships that at Tihu or Nalbari or at Guwahati, the victim could have spelled out something. Then, my lord, there is, my lord, the hypothesis of the guilt, my lord, is not explainable that only this person is. It creates out that no, the victim might have committed suicide. Third is my the circumstances should be of a conclusive nature and tendency. So, my lord, as far as that dowry part, soon before the death she was subjected to cruelty, the other aspect does not completely change in this case, my lord. That on these circumstances, it might be that the accusers burned her wife. So, my lord, that, my lord, chain has to be complete in order to bring the accused within the preview of my lord 304 and 302, my lord.
We just see that what about, there's no prescription there. I don't remember. Because I don't really remember seeing a prescription or a referral advice. I really didn't see that. I did not make any effort to say it, but normally when I flip paper, if it is a visual perception,
Yes, yes, we also
I-
get, yeah,
ah.
NBT it is sometimes.
Ah.
yeah.
I normally,
So I'm saying one paper,
Ah.
serial NBT.
because I normally, when it comes to prescription of doctor's
Lotion.
advice, I somehow retain that.
Lotion. Generally it remains.
We'll continue at 2.
Right.
We may be 5 minutes late. And-
Oh, that's every other sama. Hari kita sama. Awan, jauh sana.
Oh, lockdown. Lotion, but it's regards to the text. right?
I understand. It's from there. Yes.
Is nothing better than to my. Yes, I know. The circumstances, the court party that they should exclude every possible hypothesis except the one to be proved. And the last one, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the emotions of the accused, and must show that in all human probability, the act must have been done by the accused. So, taking up this present case, it cannot be said that the accused has committed the offense. Rather, my lord, there are reasonable grounds to believe that she might have committed suicide in view of the fact that, my lord, in connection with 304B, read with 113B of the evidence set. My lord, the other part to attract 302 is missing in this case. Because this
Please,
led to 302.
please come again.
What I'm on is that the chain of evidence starts from the cruelty, physical, mental harassment by the accused in demand of dowry, coupled with section 113B of the evidence set, madam. The 302 part is done now. So, madam, if that part is missing, the other part will not come up. Because initially, my lord, the FIR is only with regards to demand of dowry, mental and physical harassment. Thereafter, she was brought. Now, my lord, thereafter 7 days time was there, my lord. In between that, my lord, no any evidence came up to prove the previous part in order to prove the later part of 302.
Yes.
Para 23. Please stand by the explanation. Keeping in mind the above said principles, let us examine.
Writer of this judgment, Mohammed Firoz.
Keeping in mind the above said principles, let us examine whether the prosecution had proved beyond reasonable doubt that the entire chain of circumstances not leaving any links missing for the accused to escape from the clutches of law. The first and foremost circumstances regarding the visit of the present appellant along with Rakesh Jyoti on the date and time as alleged was very crucial and that was admitted by the judge. But by such admission, even his identity has stood true. There cannot be gainsaying that no condition to be based on the statement of the accused recorded in the section 313 of the CRPC. And the prosecution has to prove the guilt of the accused by leading independent and cogent evidence. Nonetheless, it is equally settled proposition of law that when the accused makes inculpatory and exculpatory statement, the inculpatory part of the statement can be taken aid of to lend credence to the case of prosecution. This court, while dealing with the issue of inculpatory and exculpatory statements of the accused made under 313 has made very observation. Now, during this judgment also, the last session, but we expect that in the 313 statement, since he denied the part that no, there was no dowry, so these parts were never denied by the accused by leading evidence in the 313, meaning thereby that the inculpatory part of the accused was there. For this only I have been. The inculpatory and exculpatory cannot be excluded. Both has to be taken. And that has to be corroborated with the evidence led by the prosecution. Only then, my lord, the conviction can be based. Only for that part, my lord, I have placed this paragraph. Now, only my one good is that event that of the Honorable Supreme Court, my lord, very well soon before my lord has been explained. Soon before the death, my lord, soon before aspect has been dealt with, my lord. It is 2018 10 SCC 593, my lord. The judgment was authored by my lord Justice K.M. Joseph, my lord. The relevant para is para 14 and 15, my lord. Initially, I did para 14, thereafter, I go for para 15, my lord.
But Mr. Tiwari, you see, you say that your wife was loitering, you broke open the gate, you saw her burning. Then what? What did you do? You are not let anything to show that you tried to douse the fire. You got you got injured while doing so, or any other member of your family. Somebody is burning in the house. You must have done something. What is that act?
That particular question was never put to me. Had that been put to me, I could have explained that part. Because, my lord, in 313, my lord, the questions are placed by the court, my lord, and not at all by the prosecution. The court takes the books of the prosecution. Because whatever evidence is brought on record, my lord, only on the strength of both. Because even if I go on asking that you have taken this in your so and so, but that question has to come from the prosecution witnesses only. A question cannot be put to the accused which are not brought on evidence by the prosecution. So 313 always limited to the evidence which has come against an accused person. Nothing more than that.
Next question is, do you want to say anything more? The answers.
Look at the last question. There you should, I think there you should have given an explanation.
Do you want to reduce any evidence?
No,
Do you want to
you have to say anything.
Do you want to say anything?
It means, okay, we can't take an adverse inference right now in the appeal, but there is a circumstance we have not explained.
People who are not even required to speak at this stage of legal trials. Keep on. Is the prosecution is required. Now, since 106 attracted my lord, for that a reasonable explanation was required, my lord. And that explanation could be at clear stage. Now, my lord, the prosecution could not bring on any evidence to show that along with the accused, some other persons were there who took them to Pihu, thereafter to Nalbari and to GMC. So it is the accused only, my lord. It is, had that been the case that some other person would have been there to accompany, then my lord, things would have been different. But here in this case, it's the prosecution who has been failed to place any such aspect, my lord. Because it was the IO who should have conducted that particular investigation with reference to the nearby people that who had taken her to the hospital, that are taking certain evidence from the PU hospital in Nalbari, who were the persons who accompanied him. Then those part, some part of effect in the investigation was there. Because had those been taken care of, my lord, had the IO came up from PU to Guwahati and took the statements of the doctors and the other staffs, my lord, then some evidence could have been brought on record. But since that part is silent, my lord, so my in that aspect, my lord, it can be only presumed that it was the accused who took, because the mother-in-law is also not disputing the fact that accused was not there or accused did not took, or some other person took. She says that somebody has said me that she was burnt, but she could not name the person. Neither she took any endeavor to know who were the persons who took her to the hospital. But had the informant herself taken some steps, there's some evidence would have been brought on the record. That part was also there, but that was not taken care of. Well, there are 14 of the Jagdish Singh judgment. Internal page 7. May I read number? Para 14. Jagdish Singh judgment 2018 65.
Jagdish Singh.
Yes, madam. Internal page 7.
Paragraph 14.
Paragraph 14 and 15. Madam.
Yes.
We have already noticed that essential ingredients of section 304 IPC as noticed by this court in Major Singh versus and another versus State of Punjab, Parliament has inserted section 113D in the Evidence Act. In order that the presumption therein has to be applied, it must be established that soon before her death, such woman must have been subjected by such person to cruelty or harassment for, or in connection with any demand or dowry. Upon this fact being established, undoubtedly the court is mandated to assume that the person has indeed caused the dowry debt as contemplated in the 304. Therefore, the presumption cannot apply unless it is established that soon before her death, a woman has been subjected to cruelty or harassment for or in connection with any demand for dowry.
Yes.
The word soon before her death has also been considered in large number of cases. There are 15 matters. We need only to refer to a recent judgment rendered by a bench considering the three learned judges in Ravindra Singh versus State of Punjab reported in 2015 666 crores in only for the purpose of appreciating the word soon before occurring in section 304 the IPC. This is what the court has to see. We endorse that what has been said by these two decisions, days or months are not what is to be seen. What must be borne in mind is that the word soon does not mean immediate. A fair and pragmatic construction keeping in mind the great social evil that has led to the enactment of section 304B to make it clear that the expression is a relative expression. Time lags may differ from case to case. All that is necessary is that the demand for dowry should not be stale but should be the continuing cause for the death of the married woman under section 304. So, this is a duty cast on me being an amicus to place before the court, my lord, the word appearing as soon before. Because I am only here to assist the lordship. So, my lord, this is what has been taken. But my lord, even his take the evidence in this particular case, my lord. From the initial part, neither the laborers have stated that they have heard any quarrel or there was any mental or physical harassment by these 3 years, my lord. That apart, my lord, the mother-in-law stayed there for 7 days, but by that 7 days, she never took any initiative to either complain to the doctor, the staffs, or to the police station, my lord. Whether she kept on silent, my lord. And lastly, my lord, she left her daughter and went to her house, my lord, after 7 days. So, meaning thereby, my lord, no. The and husband taking the risk of a person to whom, even if assuming, my lord, he has burned her, he would not have taken the chance to take her to the hospital in order to bring him within the preview of the offense he has committed. He could have tried to fled away, but that part is missing in the evidence. Now, my lord, the paragraphs in which, my lord, has came up from your lordship that the hospital staff all were there, but she had not explained. These paragraphs were considered in the judgment, but my lord, those were taken in a negative, those were not taken in a positive. If your lordship says I place the relevant paragraphs, the very first one paragraph is like page 37 of the judgment. Page 37. Para 37. Page 37. Para. Page 37. Para 15. My last line. The PW11 Tapan Purita said that the PWP did not state, my lord, that part is there. So, my lord, that did not consider the land court did not consider that as status, my lord, the PWP in that statement denied that no money. He also admitted that the witness Manika during her one sister statement did not state before him that she heard from her sister that the accused person demanded her. So, my lord, that part goes, my lord. Then, my lord, page 42, para 27. Page 41, para 27.
Yes.
Here, my lord, the learned court below, my lord, discuss 304B and 113B of the evidence section. There are 27. I'm reading, my lord. Page 41. At this juncture, I would like to discuss the ingredients of section 304B. In order to convict an accused for the offense under 304B, IPC, which deals with the dowry, that the following ingredients must be satisfied. The death of a woman must have been caused by burnt or bodily injury or otherwise then under normal circumstances. Such death must have occurred within 7 years of her marriage. Soon before her death, the woman must have been subjected to a such cruelty or harassment must be for or in connection with the demand of dowry. Then, my lord, para 28, section 113 of the Evidence Act is also relevant for the case at our hand. Both section 304B IPC and section 113B of the Evidence Act is certain to combat the increasing means of dowry debt. Section 113B of the Evidence Act contemplates as follows. When the question is whether a person has committed a debt, the dowry debt of a woman, and it is shown that soon before her death, such woman has been subjected by such person to cruelty or harassment for or in connection with any demand of dowry, the court shall presume that such person has caused the dowry debt. Thereafter, my lord, certain judgments were discussed, my lord, in this case. Then, my lord, I directly bring your lordship to page 48, para 38. Page 47, my lord, para 38. Now, my lord, last line, para 38, last line. If actually, I'll read from if actually.
Yes.
If actually deceased, now my lord, I'm reading page 48, my lord. Deceased would have been in a condition to speak on the fourth day of the incident, and certainly she would speak about the matter of involvement of her husband and her mother-in-law before the doctor attending her or any staff of the hospital who attended her. Apart from this, there is no supporting evidence from the doctor regarding condition of the health of the deceased on the date of giving the dying declaration before her mother, so as to ascertain her capability to forward dying declaration before her mother. So, my lord, here the defense counsel, my lord, placed an argument before the court that the statement which the victim has given to her mother cannot be taken as a dying declaration. So, in that context, my lord, this was taken by these arguments were advanced by the learned court. But learned court discarded, appreciated this part of the argument, saying that it cannot be termed as a dying
No,
declaration.
last two lines under the evidence of purely related to dying is not at all reliable.
Not reliable to be acted upon. So, my lord, that part was discarded that it is not a dying declaration. But reliance was taken by the learned court. It was discarded as a dying declaration by the learned court below, but it was taken as a substantive evidence, the evidence which came up from the PW1. So, there are 39 speaks about the other part. So, I'm not going on that because I've already wrote this one. Now, I'll take the lordship to page 49, para 49.
Para?
Para 40, my lord, page 49.
40. Okay.
So, though the defense argued this urged this court not to rely upon the testimony of the informant as she has been separated from her husband, leaving the deceased with her husband at the childhood of the deceased, cannot have any knowledge about the marital life of the deceased. Yet such argument is not at all acceptable, as because being a mother, definitely she will have close relationship with the deceased in her childhood as well as also after her marriage. Though she PW1 was separated from her husband. In the statement of the accused according to the CRPC, however, it is suggested or claimed that PW1 had no relationship with the deceased or no visiting terms with the accused after the marriage of the deceased with accused. This argument was advanced since this statement did not came up, my lord. So, my lord, there was no explanation on the part of the accused person. At this question being there, my lord, he could have replied to that whether her mother had terms or not. Or after the marriage, she had, my lord. Now, my lord, page 52, para 45, my lord.
Para
There are 45, my lord.
45.
45, my lord. Last 5 lines from the bottom, my lord, I will be reading, my lord. The incident of burning, my lord. My lord, what, my lord? The incident of burning happened at the bedroom, and the accused nowhere stated that any lamp or chakki was lighting inside the room so as to presume that fire caught on a body accidentally. Rather, it is stated in his statement that the deceased had committed suicide. Doctor evidence makes it clear that due to burn injuries to Tulika died. So apparently the death was not caused under normal circumstances. The death of the Tulika was caused during 3 years of her marriage. The accused could not rebut the said presumption that the death was a dowry death, though cross-examination of the woman to the beauty or by using any evidence. So with the aid of section 113B of the Evidence Act, the court presumed that the disease whose death was not caused under normal circumstances is a dowry death and the accused has committed dowry death. This is the presumption with the Lamed Court below took my lord in convicting the accused, my lord. Thereafter, my lord, in paragraph 47, 48, the Lamed Court below, my lord, the judgment which I have read, my lord, is Sarat Digital Startup case, my lord. Those were the circumstances, my lord, leading to the chain, my lord, were discussed, my lord, and thereafter these judgments, my lord. Thereafter, my lord, paragraph 50, my lord, paragraph case 56, paragraph 50. I read, my lord, paragraph 50, page 56.
50.
Paragraph 50, page 56, my lord.
Yes.
In the instant case, it is seen from the statement of the accused that the occurrence took place inside the bedroom of the matrimonial house of the deceased. So, under such circumstances, it is really difficult for the prosecution to give evidence how the incident happened. Because the mother and other family members of the deceased stayed at a different place and it is not possible for them to witness the occurrence of burning. As such, the demand of dowry and torture relating to the dowry, the relatives of the deceased could not say how actually the incident of burning happened. The neighboring witness also probably do not want to be inimical to the accused, who is their neighbors by deposing against the accused. The neighbors are generally reluctant to depose against their neighbor. So, this aspect was also taken care of by the Lamed Court. And page 63, my lord, paragraph 59, my lord. Paragraph 59.
59.
59.
Yes.
It is the settled law that a plausible or cogent explanation should be given by the accused during his reply and the purpose she has to say when his wife sustained burn injuries in the dwelling house of the accused. Coming to the case at our hand, let me see whether plausible or cogent explanation could be given or not by the accused. In the instant case, the door of the room was stated to be seen by the accused, bolted from inside after he returned from the bathroom in the morning of the day of occurrence. And if the room was found bolted from inside and his wife was burning inside the room, where a 2-month-old baby of the disease was also present, then in such a situation, definitely a normal man will have immediately get you and try seeking help from the neighbors or from the other inmates of the house. But nowhere from the statement under 3-month case, it appears that the accused raised any view and cries so as to draw the attention of the inmates of the house or neighbors. Those statements shows that there were other inmates in the house in separate rooms, and near the PO there are houses of adjacent neighbors. Yet the accused, instead of raising any hue and cry, opening the golden door, remained silent and stated, He opened the door forcefully. Neighboring witness also did not say anything about the hearing and hue and cry raised by the accused in the morning about 6 a.m. on the day of offense. If the accused would have raised any hue and cry, seeing the door bolted from inside and his wife burning, then suddenly PW3 man who admittedly himself as the neighbor of the accused and PW4 Krishna Swajari, wife of Officer who is shown as the neighbor as per the statement, who had definitely heard the hue and cry of the accused as he was morning time as villagers got up from bed at 6 a.m. However, those neighboring witnesses remained silent in this regard. Evidence is lacking from the defense to show that the door was bolted from inside. The statement recorded in students regarding finding the door of the bedroom in locked condition from inside while he came out from the bathroom and opening doors forcefully is found to be very much doubtful. His conduct is not seeking help from the neighbors is also found to be very much surprising. If he would have forcefully opened the door, then certainly there would have some damage in the door or part of the door would have broken, but nowhere the IO who visited the place of the game disclosed anything about any damage of the doors or lock. The accused neither admitted any evidence in support of his plea nor examined himself at the establish the door was locked from inside and that he used to be open. Here, my reply would be that one of the IOs, my lord, the three IOs would be both before the London court below my lord. In the chief, did not say anything about the doors being broken or doors were not broken, my lord. And those evidence could have been made by the IO, then there are a cross-examination to the other. See, those expressions are not taken up in the chief, my lord. So, my lord, the defense would never cross-examine on those points. These were rather assumptions of the learned court below, my lord. Nothing more than that, my lord. And the questions which came up from your lordship, my lord, is also taken care of by the learned court below, my lord. There are 60, my lord. Page 64 only, my lord. There are 60. The accused never stated that he attempted to extinguish the fire on the body of the PG. So this conduct of the accused is also surprising. If he tried to extinguish the fire, then certainly he would have also received burn in his hand, body. But in the initial case, evidence is taken in this regard from the side of the accused. So, my lord, to that explanation, what I place before your lordship is that I was also there in the burn cabin, burn ward of the GMC, my lord. If I had got certain burn injuries, my lord, since I was there, my lord, the doctor might have treated me. Since the IO, the prosecution did not bring down the GMCH and took, my lord, appropriate statements and evidences from them, my lord. So, my lord, now, my lord, being in amicus, my lord, I'm also unable to place that part. Because had the since you are there to be one what suspense again.
Is your speaker on?
So, Mother, definitely it cannot be said that he did not sustain any burn injury. Because no evidence, neither the prosecution brought my lord, or neither my lord, while a person is taken into custody, my lord, his medical examination are generally done. But in that case also, that my lord, particular aspect is not there. I've seen one report, I have not find that. Otherwise, my lord, after 7 days, that could have taken at least the attending doctor prior to sending a person to jail. Generally, they examine. My lord.
It's there. That memo should be there. I have
That
not
memo
seen it.
should be there, but that memo, my lord, to my understanding, my lord,
It's not there. I
about
did
the
not check
burn
that.
injuries, nothing has been spelled out. My lord. So,
I
my
did not check that.
full submission, my lord, some of my think that my lord, the conviction is based upon only 304B. If 304B is accepted in this case, then my lord, 302 will follow. But in this case, my lord, the demand of dowry, cruelty, method of my lord, that part is missing, and that part, my lord, the conduct of the accused, my lord, staying throughout in the hospital, my lord, he was there, and my lord, he tried all his possible efforts, my lord. It is the case of the prosecution itself, even the informant that we took her to the TU hospital, thereafter to the Nalbari, and thereafter to the JMCH, my lord, meaning thereby that his conduct was to save his life, not to kill his wife. And my lord, had there been some cruelty meted out, then the neighboring could have spelled in some different manner, my lord, but could have spelled out in their evidence. That we heard, sometimes we heard that there were children crying in their house. But no any manner, my lord, any of the independent witnesses present, and neither the IO has spelled out that these witnesses have said this, but that part is loose. So in my humble submission, my lord, this and if you're blessed.
When the occurrence takes place inside the four corners of the house, then your lordship, of course, the prosecution has to stand on its own legs, but burden is lesser on the prosecution when the date is committed in the four corners of the house, and the inmates of the houses has to give a plausible explanation, and it's up to the court to decide whether the explanation given by the accused persons are sufficient and whether it would go adverse. Lordship, if the honorable court comes to a finding the explanation given by the accused person is wrong, or if it gives a lordship which is false, your lordship, it gives an additional link to the circumstances. So in this case, your lordship, mother is the person who talks about dowry, your lordship, there's a demand of dowry, your lordship. Apart from that, one more witness, it is PW2, who talks about the demand of dowry immediately before the occurrence. Lordship, PW1 in a 164 statement has also deposed, lordship, there is a demand of dowry one on 28/2007. And that has taken place, lordship, incident has taken place in the midnight manner. So your lordship, there is no possibility that any third person would come inside your lordship in the early morning or in the midnight. Somewhere it's written it's midnight, and somewhere as in the explanation given by the accused person, early morning, your lordship. Then your lordship, although some of the conducts of the accused person goes in his favor, but regarding the other conducts, what did he do immediately after the occurrence, my lord? What steps he had taken, having come to know that his wife is burning, whether he tried to extinguish the fire, my lord, whether he put any water on her body, whether he tried to put any medicine, nothing is given, nothing is on record, your lordship. No explanation to the in that regard is given by the accused person. And regarding the pouring of kerosene, and he has not taken any plea whether lamp was burning, your lordship. Admittedly, it seems, your lordship, there was no lamp because, your lordship, they had guest room, they had separate kitchen. Lordship, if could have been, it could have been, they cook the food inside the, sometimes the poor people, they do, lordship, in one room they stay and they sleep in one room, and in the same room they cook also, your lordship. But in the instant case, as far as Sketchweb, kitchen is separate, your lordship. And from where this kerosene came, your lordship, from where this lordship, the matchbox or whatever, out of which the body was burnt, your lordship, that the deceased was, before her death was burnt, your lordship. Nothing is on record. Then, your lordship, there's oral dying declaration given to her mother, lordship, immediately before her death. After 3 days of the occurrence and before her death, your lordship. And your lordship, will kindly note one thing, they had a love marriage, my lord. And if your lordship considers age of the victim, she was only 17 years at the time of her death. So prior to 3 years, she got married. So lordship, unless something would have happened, she would not have named the accused person, my lord. And since there was a demand of dowry, your lordship, that's why the relationship became strained.
You're referring to whose evidence?
Lordship, in general, I'm talking about, if your lordship considers a postmortem report, the age of the victim is 17 years.
Yes.
My lord.
Yes.
And they have, lordship, they got married prior to 3 years. So it is 14 years. And your lordship, it was a love marriage, your lordship. It's not a, like,
Correct, correct.
out of force,
Correct.
they were given marriage.
Correct.
So normally, your lordship, in a love marriage, unless the relationship is strained, lordship, she will not have named the FIR, named the accused person in the FIR. And apart from that, she is having a 3-month-old baby at the time of her death, my lord. So, Lord,
FIR was given by the mother.
mother, my lord.
It's not the victim who has said anything against the husband.
Against her husband, but as per the evidence of the mother, before her death also she has complained. There was a demand of dowry. And she was stopped coming to her daughter's house, my lord, as because she could not fulfill the demand of dowry, my lord. So, your lordship, as the victim could not fulfill the demand of dowry, as a result of which she was killed by the accused person. And your lordship, of course, the delay in in lodging the FIR. My lord, but your lordship, in the distant case, your lordship, I think the circumstances and whatever facts the informant will depose, my lord.
No, but
regarding
there are
delay.
some gaps. You have to just explain. Come to page
Lordship.
9.
Page 9.
9.
Lordship.
This is in 2012. Correct. This
Yes.
evidence is of 2012.
Yes.
Their marriage took place 6 years ago. That means 2006.
Yes, because
So-
lordship, they
No,
got
I'm
married in
just-
2008.
No, that's right.
Yes.
The marriage took place in 6 years ago. That means page 9. That means it was 2006.
2006.
Now, as a result of the wedlock so marriage, after the marriage, the Department of Police so after marriage for 3 years, I have visiting terms. That means 2006 to 2007, 8, 9.
Yes.
But then the incident over in 2007.
But lordship, in Shivantri's statement, he also says that 3 years.
It's okay.
Yes.
But what is the date of marriage? That's not come.
No, it hasn't come on record.
So therefore, if we take the evidence of PW9,
My lord. PW?
sorry, PW1,
PW1.
then what does it transpire?
It's 2001. Incident occurred in the year
She
2007.
was
7.
2008.
Prior,
FI 2008, my lord.
You have to say 2006. Marriage took place 6 years ago.
marriage took place about
6
6
years
years ago. no?
That is 2012.
It will be 2006.
Evidence of 2012.
July 2012.
Okay.
So that
It
is
will be
2006.
2006.
6.
Yes,
So after 3
Date
years,
of
they
occurrence,
stopped. I
2008.
just
yes, ma'am.
we are
Within 1 week.
no, we are trying to convict someone on the basis of her statement.
Yes.
So I'm just testing that veracity.
I just highlighted this, but I thought that there might be a mistake in writing. So
But specific date of marriage is
No,
not there.
I'm not glad. But we are seeing we are convicting someone on the basis of the statement. So
Yes.
I'm just testing that
My
statement.
lord, my lord.
So
Not your lordship, at the same time, there might be inconsistencies here and
no,
there.
that's okay.
Yes.
That's okay. But you see, that means For 3 years, they had visiting terms.
Yes.
That means it crosses the date of the occurrence. You see, the
Yes,
relationship
yes,
must
yes,
stop
yes.
at some place. Their relationship must have snapped at some place.
Yes.
What is there? On which date that happened?
My lord.
Because you see, there is a demand of dowry.
Yes.
The demand of dowry is of which date it's not there.
It's not there. But according to her, 3 years. For 3 years she used to come and she could not fulfill the demand of dowry. So your lordship, they have stopped herself from coming to their place.
Correct.
Lordship is correct in saying, your lordship, that the timing doesn't have a date doesn't match.
It doesn't match.
Yes.
So the marriage date is not
My
there.
lord.
Because you see, at the time of death, she was 17 years.
Yes.
Therefore, if we take 6 years,
Yes.
then she would be 11 years at the time of marriage. It's not possible.
Maybe they eloped, my lord.
No, it's okay, but she's 11 years. That's not the date of age of elopement. I would have understood 15, 16 years, okay. Let us come down to 14, okay. 11 is not a year of elopement. Age of elopement, sorry.
It's written here, 11. Lordship, she was a student of class 11, 7, page 12. 7 means it would be,
7 that should be 11. 7 should be 11 because metric would be, what you call, metric would be 16.
16.
So with something somewhere
13.
11 to 14 years
Yes.
should be.
As per evidence of PW2, she was in class 7, that time she eloped.
Correct.
Oh, your lordship.
14 would be okay, very
Yes.
acceptable. But then you see, the improbability. Let us assume she was 14 when they eloped. Marriage took place sometime we don't know.
Yes.
The incident occurred after how many years of marriage, that is also not known.
Yes.
Correct. But the incident happened in 2007.
And, 2008.
Huh?
2008.
Uh,
2007,
2007.
I'm sorry.
2007.
2007.
No, but then you see the inconsistency in the age.
Lordship, I mean to say, I have brought in the age factor because your lordship,
No, even you see from the date of postmortem,
yes,
even is 17 years. Then the marriage, even if we accept the statement of the mother 6 years ago, so 6 years ago would make her 11 years.
Lordship, I have brought that, back.
No, I'm not questioning your
Yes, my
statement.
lord.
I'm not questioning your
Yes.
statement for a moment.
My lord,
I'm just trying to understand the age
Yes,
from the
ma'am.
marriage.
yes, ma'am.
Because
They
then,
say we love my lord, they did not, because out of love they have married my lord. They got married in Kamaikha temple. So I mean to say, your lordship, since in a very young age she came over, it was a love marriage, she will not firstly name her husband, my lord. And living apart her 3 months old baby, she would not commit suicide. I mean to say that, your lordship.
you know, it's a strange world now.
And your lordship, since there is demand of dowry, and she could not fulfill the demand of dowry of the accused, your lordship, as a result of which she was lordship burnt. Although there were lapses on the part of the prosecution, they could have recorded the time declaration. But nothing, your lordship, that did not falsify the prosecution case, my lord. And your lordship, other part, your lord, my learned friend already, lordship.
You see, is a mere statement that there was a demand of dowry sufficient to incarcerate person? You see, what is the demand made?
My lord, that is not,
It's not
that is
there.
not there. Except these 2 persons, aunt and the mother, nobody talks about it.
But then today morning I demanded a dowry. You see, it's just a lighter note I'm saying. My wife has gone to her brothers to tie Rakhi. And I told her, bring some sweets for me.
Yes.
So I told her not to eat alone, but bring some sweets for me.
It should not be valuable, by the valuable demand.
I don't know. I don't know. But I also made a demand for dowry.
Yes.
Now the question is, if it is not quantifiable, data is not available. Then what was the demand for dowry? Is a demand for sweets good enough to bracket it as a demand for dowry? Or dowry must be something which is which otherwise appears to be it has to be a dowry.
Dowry is
And Dowry Prohibition Act.
304, the dowry is defined under dowry prohibition.
No, but what is the you see? It must be something.
Nothing is there on record. What
Something
demand
is
was
there.
there?
What demand was there is not there. Even the prosecution never asked her. The prosecution did not question the witness, saying that what is the demand.
Yes,
Date of demand is not there.
my lord.
So if 304B,
Yes, yes.
304B, the demand must be continuous.
But soon before, I have got one judgment or not the Supreme Court, I'll refer that. Soon before, it may not be. Lordship, that factor which my learned friend has cited, like soon before the demand was, it may not be, my lord, as per 2022 5 SCC 401. It's a constitutional bench judgment,
You see, we understand the status of these people.
my lord.
Here, what Mr. Tiwari has said, that after the incident, he had to send his brother to the mother's place to inform.
Yes.
That means they don't have access to mobile. Therefore, they are not from they don't appear to be from even a middle class stream.
But
No,
the
somebody-
sketch map shows they have got guest room, kitchen,
No, that is,
yes.
no, that is okay. But look at the,
Yes.
because they did not have the means of communication. Otherwise,
Sometimes, it may so happen, my
no,
lord.
no, no,
Bad news, they don't give it like over phone, so like.
no,
they
no,
have
no,
sent
no,
in order to bring
no, no,
them-
because the Lalit Sessions has taken exception to that.
Yes.
He says, in the interim judgment, the court has taken an exception there. Therefore, I am asking this question.
Yes.
There are 14 and 55.
14.
Seventh line, madam. Evidence of PW1 state that the brother of the accused Vikram came to her house.
No, not that, not that. Because somebody says he saw the fire, he did not raise a hue and cry. He broke open the gate, did not take an aid from the neighbors.
Yes, this is there.
Correct.
Yes.
There is one statement like that somewhere.
Lordship, para 59, page 63.
Huh?
Para 59, page 63.
59.
59, madam, there are.
No, I won't remember because I don't know.
If the room was found bolted from inside and his wife was burning inside the room, where a 2 months would degree of the people are also present, then in such a situation, the normal man would have immediately raised hue and cried, seeking help
Huh.
from the neighbors.
So you see, an exception is taken because I go and break open the door or whatever I do to bring the victim out. That is questioned by the court by saying that you should have shouted first. So therefore, you think of the situation in this courtroom. This book has started burning for some reason. The camera is there. The book has started burning for some reason. Now, if I douse it, I am being questioned. I should have shouted, "Fire, fire!" Then 5 of you must have heard it, and then come to save this book from burning. Then only I save myself. But this is not something which can do. Whatever I can handle, I'll do it.
Yes.
Because,
Here, the accused
No.
person did not do so.
no. He took it out, that's why the victim went to
Immediate
hospital.
state might not to pour water.
No, but no, it's okay. Water, I did not pour it. But now medical science will say that non-pouring of the water is good. You know that?
Yes.
You'll be knowing because you have doctors in your family. Because it says that you can wrap her in a, but putting of water is now prohibited. So therefore you can't question. But the fact is that the victim from that house went to the hospital. Somebody must have taken it. Who is that person? Otherwise, Mr. Atal says that you have to take a presumption that it is only the accused who has taken her.
Yes, yes, that is there. I have also admitted that. He has there, he was all
Yes.
along. He was all along. It is not a case of the prosecution, he was absconding, my lord. He was
Yes.
all along. He took all possible
So therefore,
steps,
he did
except
not-
Loshi, immediate step he did not take it. He has not taken the immediate steps. Did not take any
Immediate
immediate
step was
steps.
shouting.
Shouting and pour. Treatment, nothing is on record, my lord.
No,
Even
no,
now,
no.
I know there's a lapse on the part of the prosecution, whether they have visited the place of occurrence, whether the door was like it was broken somewhere, lock was broken, nothing is there.
No, but that presumption can't be taken. This presumption can't be taken. You see, please tell me, can a negative presumption be taken? How far a negative presumption is permissible? You see, the IO does not inspect the gate. He does not make a note of inspection of the gate. And therefore,
I have not seen the CD to the left of my.
no,
Yes,
otherwise
but
it
it's
would be
not
there in
on
the,
record.
it will
Not
be
on
there in the,
Yes.
in the judgment.
Yes.
It's not there.
Right.
So you see, therefore the condition of the gate is not recorded. Under that circumstances, is it permissible for us to take a presumption that the accused did not give an explanation that the house door was not broken?
No. Oh, your lordship. Under 114 of the evidence.
You see that there is nothing, that presumption is not there. Negative presumptions are not there. The presumptions are normally in the affirmative. Presumptions are always positive.
Concern is certain possibly grave. 114A as my website.
304B, there is special presumption.
133.
304B.
There are special presumptions.
113B.
113B.
114 also few presumptions.
One and three B will fall. It's not there. That evidence is not there. That immediately before that she was. You see what would happen in a family. Let us say I do not treat my daughter-in-law well. Two people of the community will or her family would come and say that please desist from doing it. Or the neighbors. Now neighbors say that they don't have a visiting terms. And the court says that you did not call the neighbor and that is a presumption against you. Because if I am not in talking terms with you, why would I call you?
Probably the lordship cannot. Because the prosecution has to stand on its own. Since the IO did not say anything as
What
regards.
court everyone is taking a presumption against the accused. Since the gate is the condition of broken gate is not explained, therefore he is victim. He did not call the
And it
neighbors,
has to-
therefore
it
he
has
is
to-
the accused.
Intimidating matter has to be put to the accused person.
It's not there.
Plus two citations regarding the delay in lodging the FIR, mental agony of the persons, victim, and his family members as regards delay in lodging the FIR. And one that famous Timur party can.
No, but how do you explain what Mr. Tiwari has said?
My lord.
With all those adversities,
Yes.
the mother-in-law ultimately left the dying daughter with the husband and left. If you doubt me,
Yes.
will you leave someone who is dear to you in my custody?
Just before her death. Just before her death.
She
Maybe
went
there
home.
are some inconsistencies regards that some
No,
ways
she went home.
even after death.
No,
After death, she has gone home.
no, not after death. It says on the 7th day I left home, after that she died. That's her
Somewhere I
evidence.
found your lordship after the shade.
No,
Let me check.
Page 10, my lord.
huh?
Page 10, my lord.
Pages I was not.
Page 10, my lord. PW1 evidence, my lord.
I was there for 7 days with my daughter. After that, I came to my residence, and on that day she died. Page 10, right? You see, then there's one more thing. When can a dying declaration be taken? What is the principle?
Anytime, there's no specific principle as such as what. If the condition
No,
of
she should be in the imminent threat of
the
death.
she should be considered, my lord, as per the certificate of the doctor is not a mandatory
No,
requirement.
it's not.
Yes.
But I'm just asking
I
you,
know.
what should be the principle?
Yes.
The statement, when did the victim say that she was burnt on the 3rd day?
On the third day.
Correct.
Yes.
So 3rd day means she was the victim was alive.
She was
4th,
alive.
5th, 6th, 7 days. 4 days she is alive. No attempt is made to get a statement recorded
My lord.
in accordance with law.
Not sure. That is one, that's the solution.
No, that condition is not recorded. Nowhere it is recorded what is the condition on the 3rd day, on the 1st day, on the 7th day. A condition throughout the 7 days of hospitalization is never recorded.
In a case that I did there, the police said that they did not think that the person will die. And so they did not record the dying declaration. So those facts can also be there. Now she was alive for so many days. They might not have thought that she died.
The problem is that now after the death we are now dissecting. After the postmortem now we are dissecting.
But there has to be some reason by the police officer why they did not record.
So we are now finding the last cause of death. We are now dissecting, we are now taking what you call examining the viscera.
Lordship, base 10. After that, I came to my residence and on that day she died. Yes, yeah, Lordship is correct. She left her daughter in the hands of the accused person.
But on the 3rd day when a statement is recorded that perpetrator of crime is the husband,
Yes.
you would not leave her even for a moment. That is an unnatural act.
Lordship, probably this person has got his lesson, my lord. Lordship, because date of occurrence is 2008. 2008, right? When he was arrested, he was immediately arrested.
He was in bail, my lord. Thereafter, my lord, since the judgment is there, 4 years, doesn't mean something like that. The audience is-
Then, my lord, I was under the impression of 2006. So
He was in bail,
2008
he
is-
was in-
No, late after the FIR, 2 days after he is arrested. So
Yeah,
he did
individual
not,
lordship
he did not make an
discretion.
attempt to.
There were lapses on the part of the prosecution.
Okay.
Lordship, should I fight? Lordship, rising.
Definitely.
Lordship, I'll give the citation.
Definitely, if you have citation, give it.
2002 5 SCC. 401, 15,
Just be slow, 2000,
2022,
Ah.
25 SCC
5 SCC.
401.
What does it say? On which point?
Immediately or soon before that interpretation is there. Immediately after the occurrence and soon before. Lordship, that differentiation by the Supreme Court has discussed about. There are 11 arguments, Your Lordship. It's a constitutional bench.
Immediately after the,
Immediately and soon before, my lord, the demand of dowry. State of MP versus Jogendra and another. One more judgment,
just pass me that book.
Lordship.
Paragraph,
No, I don't have to. 11, my lord, 11. Thereafter also.
okay, just give the citation because I have to
My
sit
lord.
for 2
Then
minutes.
2006,
Single bench.
2006, 10 SCC 681.
2000,
610 SCC 681.
661,
681, my lord.
681.
Trimukh Maruti Kirkan, the state of Maharashtra,
Maruti.
my lord. Para 15, 21 and 22.
Okay,
One
Uh,
more lordship.
huh.
Mental agony of the person lodging the FIR, the victim, your lordship. A family member of the victim. 2002, 9 SCC 147, para 11.
okay,
Vijay
because
Singh versus state of Bihar.
I have to raise them singly because there is a
Yes.
judgment to be delivered. Other matters would be gone over.
One matter is put on Friday night, I let it Friday.
Court first will take care because I have to sit singly. There is a judgment to be delivered.
Kept at 2 p.m.
So division bench judgment. Mr. Bhavan, your matter. The appeal fails when the appeal is dismissed. The conviction and sentence against the appellant is affirmed. So, when there is a single bench judgment, Mr. Sam, your matter. The petitioner is not found entitled to the petitioner is not found entitled to land allotment. And therefore, no case is made out. In view of the reasons assigned, no case is made out for setting aside the interim letter dated 3/3/2022, Annexure 3, and this Annexure 5, which is the notice dated 24/3/2022. The writ petition fails and the same is dismissed, and the interim order passed on 25/3/2022, staying the election process is vacated.
Okay.